Major breaking news out of the United States Supreme Court. Merrick Garland, the Department of Justice, and the ATF are seeking a stay of the United States Court of Appeals Fifth Circuit's decision that has enjoined, in part, the frame and receiver rule, also known as the Joe Biden propaganda term ghost gun regulations. Well, it turns out that Merrick Garland may not have any interest in precedents associated with the Second Amendment, but he certainly does when the Supreme Court rules in favor of the government. Let's talk about this emergency motion filed by the Department of Justice just now. Hey folks, I'm Mark Smith, host of the 4 Box of Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of First They Came for the Gunners. Check it out if you do not already own a copy of the blueprint to take away our gun rights by the anti-gunners in America. All right, folks, so major breaking news in the case of Defense Distributed versus Garland. As you know, this involves the propaganda term ghost gun regulations, Joe Biden's ghost gun regulations, which is basically trying to use the ATF pen in the phone tactic to expand the definition of what a firearm is to include not just frames and receivers, but also parts of frames and receivers or partially completed frames and receivers to try to destroy the self-made firearm business in America as best they can. As you may recall, about a month ago or so, the Fifth Circuit entered an order of vacatur, which means that under the Administrative Procedural Act, the Fifth Circuit concluded that the ATF, by promulgating these ghost gun regulations or frame and receiver rules or weapons part kit rules, had exceeded its statutory authority, meaning the regulations had gone beyond the scope of the statutes that had been given to them by Congress, and congressional statutes trump regulations. Regulations by the ATF must comply with and must not contradict or exceed the scope of the statutes given to them by Congress, the elected officials. But nevertheless, the Fifth Circuit said, indeed, the ATF, by changing their regulations for the first time in 50 years, was essentially countermanding the meaning of these congressional statutes dealing with the definition of firearms, which included the definition of a frame or receiver to include parts of frames or receivers or incompleted or partially completed frames and receivers, and all of a sudden those became guns as well, or firearms as well under federal law. The Fifth Circuit says, you guys are crazy, this is obviously not allowed, and entered the order of vacatur. Now you know that the remedy of vacatur is under the Administrative Procedure Act, and what the vacatur remedy means, that if a rule promulgated by a federal agency such as the ATF goes beyond its authority, then the remedy of vacatur can be granted by any judge in America. Vacatur means that the rule promulgated by the ATF is null and void ab initio, which means that basically it's as if the rule that ATF promulgated never existed because it is null and void, ultra vires, beyond the authority, and goes bye-bye. That was the order entered by the Fifth Circuit about a month or so ago. Merrick Garland sought an emergency stay of the vacatur order to the U.S. Supreme Court, and the Supreme Court, unfortunately, in a 5-4 ruling that included Justice Roberts and Justice Amy Coney Barrett siding with the liberals, and agreed that the order of vacatur should be stayed. But nevertheless, that specifically said the order of vacatur should be stayed. The reason why that's significant, and you would know this if you follow the 4 Boxes Diner channel, because I make you the smartest person in the room, even if that includes anti-gun professors and so on. I will make you smarter than they are, I promise. Nevertheless, the point is that order from the Supreme Court was specific to the remedy of vacatur. It did not cover a different form of remedy, which is known as injunctions that are party specific. So the case of Garland versus Defense Distributed, or Defense Distributed versus Garland, all right, the way it works, went back down to the Fifth Circuit and the District Court. There was a motion for a preliminary injunction on behalf of a couple of the parties there, specifically Black Hawk Manufacturing and Defense Distributed, asked for injunctions, not for the remedy of vacatur. That was precluded by the Supreme Court stay order, but they asked for the remedy of an injunction that says that indeed the ATF should be enjoined from enforcing this unconstitutional illegal rule against Black Hawk Manufacturing and against Defense Distributed and against their customers. And basically the District Court entered an injunction order, which makes a lot of sense. And then the Fifth Circuit agreed that indeed the injunction was warranted here on the grounds that the Supreme Court decision only said you could not use vacatur as a remedy. It spoke not to other forms of remedies such as injunctions. And I flagged this for you. We talked about this a few weeks ago on this channel a couple different times to teach you the difference between vacatur and injunctions. Very important to know that if you want to be a Second Amendment geek. Nevertheless, what happened is Merrick Garland has now sought an emergency stay. Specifically, it's an application to vacate the injunction pending appeal entered by the United States District Court for the Northern District of Texas. Now, what's most amusing about the story here is that, as you know, Merrick Garland and the Department of Justice have no respect for precedent, no respect for Supreme Court precedent. They don't care one iota about Heller. They don't care one iota about Bruen. In fact, if you look at their brief in the Rahimi case, they don't even quote the Bruen standard. They care nothing about the law, the rule of law, Supreme Court precedent. Nevertheless, in the height of hypocrisy, Merrick Garland comes out here and like, woo, please, Supreme Court, we need to respect your stare decisis. We need to respect your decision. The lower courts are not respecting your decision. Isn't that interesting? So when it comes to all other aspects of gun law in America, the Merrick Garland doesn't care one iota that you have lower courts, the inferior courts, as defined by Article 3 of the U.S. Constitution, running all around here, thumbing their nose at the Supreme Court, thumbing their nose at Bruen, thumbing their nose at Heller, and they're perfectly fine with that. Joe Biden and Merrick Garland, perfectly fine with that. That's right, milquetoast moderate Merrick Garland, perfectly fine with all this. But when it comes to a government interest, oh my God, oh, help us, Supreme Court. They're not respecting your precedents. They're not respecting your orders. Oh, really? So here is exactly what Merrick Garland and his jolly band of Rangers there in the Solicitor General office has said. Here's what they said, quote, "This court, the Supreme Court, should vacate the district court's unprecedented injunction for the same reasons it stayed the district court's vacatur of the rule." Injunction versus vacatur. Be smart. Injunction for the parties. Vacatur wipes out the whole rule for the whole country. For the reasons it stayed the district court's vacatur of the rule. The Supreme Court has already concluded, precedent. The Supreme Court has already concluded that the government has a sufficient likelihood of success to warrant relief. It has already rejected respondents' arguments based on the purported harms they would suffer if they were required to comply with the rule. And although the district court's injunction is narrower than the prior vacatur order, it imposes essentially the same harms on the government and public because respondents are commercial distributors selling their products over the internet. The injunction ensures that ghost guns, right? Unserialized guns, set that issue aside for a moment, remain freely available online. Indeed, respondent Blackhawk Manufacturing is already capitalizing on the injunction, touting its status as the last court-protected 80% frame and jig manufacturer in the country and offering 10% off your order. Other manufacturer plaintiffs have now sought their own injunctions. Absent relief from this court, the Supreme Court, therefore, untraceable ghost guns will remain widely available to anyone with a computer and a credit card, no background check required. Finally, and remember, this is Merrick Garland, milquetoast Merrick Garland, right? Doesn't care about Second Amendment precedent anywhere in America, but when the Supreme Court sets a precedent that helps the government, it's, oh my God, we must protect the precedent of the Supreme Court. We must respect the Supreme Court as the Supreme Court and not let these inferior courts thumb your noses at it, which is exactly what this hypocrite is arguing to the Supreme Court, right? He wouldn't say this about Second Amendment precedent, but he says it about an order that's favorable to government interest. He continues on, quote, "Finally, quite apart from the merits of the arguments that supported this court's prior grant of a stay, the Supreme Court's intervention is warranted for an additional and more fundamental reason. The District Court and the Fifth Circuit have effectively countermanded this court's authoritative determination about the status quo that should prevail during appellate proceedings in this case." Ha. Are you kidding me? Mr. Hypocrite, Merrick Garland is here saying, oh, Supreme Court, oh my God, they're disrespecting you. Step in and help us. Would not do that for Second Amendment plaintiffs, would he? Again, the District Court and the Fifth Circuit have effectively countermanded the Supreme Court's authoritative determination. I don't hear language like that out of Merrick Garland when lower courts all across the money thumb their nose at Bruen, Heller, and the Second Amendment's text. You don't hear that language by the Department of Justice, do you? No, you don't. And it goes on to conclude, in doing so, the lower courts openly relied on arguments that this court, the Supreme Court, had necessarily rejected to grant relief that this Supreme Court had withheld. You're going to laugh out loud at this. Ready for this? The Supreme Court should not tolerate that affront to basic principles of vertical stare decisis. Vertical stare decisis. Do you know what that convoluted phrase vertical stare decisis means? It's really simple. It's what we've taught you here at the Four Boxes Diner every single day. Under Article 3 of the U.S. Constitution, you have a Supreme Court. That's the big honcho. Then you have inferior courts. Now, Merrick Garland can't say that. What he says is the Supreme Court should tolerate that affront to basic principles of vertical stare decisis. Vertical stare decisis. What, you got to go back to Latin? I mean, come on. Where are we going here with this? The bottom line is what he's saying is what he never says in the Second Amendment context, which is the Supreme Court precedent. They're the Supreme Court. You guys make all the big decisions. We must respect you. Of course, we don't respect you at all in the context of the Second Amendment. But when it comes to governmental interest and it comes with, staying lower court injunction in favor of companies that will otherwise go out of business because of this clearly unconstitutional, illegal regulation by ATF. Oh, we must respect the stare decisis and precedent and words of the Supreme Court. Oh, yeah. Anyway, I think you can see how this is the height of hypocrisy. But the bottom line is this. Obviously, we're going to see what happens over the next week or two. I suspect the Supreme Court will enter an initial administrative stay of the Fifth Circuit lower court's decisions just for them to assess it internally. And we'll see what happens. I'm sure the Supreme Court is busy with it at the start of its new term. But again, here you have Merrick Garland, Department of Justice, and ATF trying to argue that the injunction entered in favor of Black Hawk Manufacturing and Defense Distributed as well as their customers should be enjoined and paused, i.e. stayed, pending the outcome of this appeal. And again, what's really offensive to me, here's what's offensive to me. So if you think about it, that we're going to have 12, 18, 24 months of litigation over things like whether or not this frame or receiver rule, this ghost gun rule, is constitutional, is legal. There's going to be a lot of litigation about this, a lot of debate, a lot of research and whatnot. And here's the thing. So the status quo that's being preserved is really not the status quo. The status quo to be preserved should have been the status quo that existed for 50 years. That is, that partially completed frames and receivers are not frames and receivers because the statute for firearms says that firearms are frames and receivers and not parts of frames or receivers. So that should be the status quo that's protected. Because here's the problem. The current way the Department of Justice and the Supreme Court for the moment is defining the status quo is that if there is any doubt about the legitimacy of this regulation, we're going to send American citizens to prison for violating the federal law if they violate this new regulation that was just made up by whole cloth by a pen and a phone, Joe Biden. So rather than have the status quo be like, look, we're not sending anyone to prison while we figure this out for the next year or two. We're going to litigate this case. We're going to do it the right way. And no one's going to prison while these questions presented, which are legitimate questions about the rule of law, are presented and resolved. No, they've got it backwards. Instead, while all this stuff is getting worked out by the courts, the presumption will be you, the American citizen, and the people in this business, if you violate that regulation, which is of questionable, dubious grounding and lawfulness, the presumption will be you get to go to federal prison. Now, that is not how a justice system should work. That is not what the Justice Department itself should be asking for. Because if you remember, in theory, what the Department of Justice likes to say is, we don't pick sides. Our side is justice. We want to make sure justice is done. Well, justice is not being done when the next 18 to 24 months you have American citizens at risk of going to prison over a dubious law, a dubious regulation that is literally being vigorously challenged in court. That is not the way justice should work. That is not the way I would do it if I was running things. Again, when in doubt, you should always opt for freedom because America is the land of the free, in theory, which means that you don't have to go mother may I and beg permission to do something. The presumption is if you're told, unless you're told not to do it, you get to do it. This is different than a totalitarian regime that says unless you go mother may I and get permission from the government, you're not allowed to do it. We're supposed to be the land of the free. And behavior like this and judicial proceedings like this, to me, suggest that we're not the land of the free the way we once were and the way we should be. All right, folks. Anyway, I will let you know what happens in the U.S. Supreme Court. This was an emergency application just filed, and we'll see what happens, what the Supreme Court does and what Merrick Garland says, and, of course, what the responses are by the respondents, and we'll see what happens soon. All right, folks. Hope you learned a little bit something today. A lot of breaking news, a lot more to talk about later today in other videos. And, again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.